You see, justice system, law and order, these are meant for the people of this country. It is not meant for the Prime Minister or the President or the governance of this country. It is meant for the betterment of the people of this country. Thus, designations and chairs don't don't build or break your character. Like if I am sitting in one chair, tomorrow if I sit in one chair, my ideology will change, my thought process will change, my thinking will change. Doesn't happen. My thinking, my ideology, my character remains. No. Regardless of what chair I occupy, whether I am an advocate or whether I am a judge. I wonder, why this opaqueness? Why this opaqueness? Why are people not allowed to see what happened in the court? Why shouldn't an ordinary citizen see what is happening in the court? Why doesn't an ordinary citizen get a right to understand that this is what the judge said, this is what the litigant said, and this is what finally the justice was? Namaskar. Welcome to another episode of Editorial. You see, in a legal system in our country, which is already stretched very thin, the problem is, can accused standing in front of a judge say that, listen, you know what, I am accused, I am not very sure whether this judge will be able to will be fair with me, or I believe that this judge is biased because I think this judge has an ideology which is very different to me, and so on and so forth. Can an accused have the right to say that? Because a lot of people will say that, listen, you know what, you anyway have crores of cases pending. Uske upar se, if accused starts saying that, ye judge theek hai, this judge I don't like, this judge I am not very comfortable with, is it fair? And will our justice system work that way? That's a very valid point. We need to think about it. But then we also need to think about another valid point. You see, justice system, law and order, these are meant for the people of this country. It is not meant for the Prime Minister or the President or the governance of this country. It is meant for the betterment of the people of this country. It is finally to serve you. And if a process that is meant to serve the people of this country, if that process itself is non-transparent, if that process doesn't give me the confidence that I will get justice when I go to a court, then what is that process worth? You see, if I genuinely feel that a judge may not be fair to me because maybe his or her ideologies are different to mine, then do I have the right to question? Because even as an accused, in this country of mine, you have rights. There is human rights for every human being. A Kasab, a terrorist, was treated with proper human rights without infringing his human rights violation. We have treated him well. So the point is, even an accused has rights. Are we taking away that rights? When we say that, no, recuse kya hai? How can recuse? What recuse? What do you mean recuse? Are we taking away that rights? This is a question which we also need to parallelly remember. And that's where my argument starts. You see, I remember 2023, and I've done an editorial on this. There was a judge called Gowri Victoria. Gowri Victoria in 2023 February was appointed as additional judge in Madras High Court. And during that time, we had spoken to you about various incidences wherein she, somewhere in 2012, 13, 18, during these years, had made statements like, as far as India is concerned, I would like to say Christian groups are more dangerous than Islamic groups. Both are equally dangerous in the context of conversion, especially Love Jihad. This is what this judge, she was not a judge then, she was an advocate then, and she was also a member of Bharatiya Janata Party. But these are the statements that she made when she was an advocate. 2012, like I told you, between 2012, 13, 18. She became a judge in 2023. So she didn't make these statements when she was a judge. Let me be very clear about that. But this is what she made, this is what she believed. Statements like the problem of Christian is the Islamic terror is green terror and the Christian terror is white terror. Bharatnatyam should be not danced for Christian songs. How could the posture of Lord Nataraja be equated to the name of Jesus Christ? This is what the judge says. Like I say again, let me be very clear. She was not a judge when she made these statements. She was an advocate. She was also a member of the Bharatiya Janata Party. Later on, she went on to become a judge. But tell me, if I am a Christian and my case is being heard by her, she is going to give me justice. Do you think as a Christian, I will be comfortable if she hands me the justice? Would I even trust her justice? Would I think that she would be fair with me? If I won't and I ask for, a different judge, am I wrong? Am I wrong? Do I have that right? And if I don't, why do I not have that right? And does designations and chairs don't build or break your character? Like if I am sitting in one chair, tomorrow if I sit in one chair, my ideology will change, my thought process will change, my thinking will change. Doesn't happen. My thinking, my ideology, my character remains. No. Regardless of what chair I occupy, whether I am an advocate or whether I am a judge, or whether I am a politician, or whether I am a journalist, or whether I am a fruit vendor. These things don't change, with designations. So that's the point. Think about it. Now, let's come to the topic at hand. We broadly understood what the situation is, and now let's come to the topic at hand. Now, on 20th of April, that is day before yesterday, Kanta Sharma, Justice Swarna Kanta Sharma of the Delhi High Court passed her judgment on Arvind Kejriwal's recusal plea. Now, in her judgment, she said that, listen, you know what? The applicant did not come with any evidence, but rather with aspersions, insinuation and doubts. She emphasized that for a judge to recuse, there must be reasonable apprehension of biases based on objective material rather than personal fears or perception of the litigant. This was her first point. She said, by mere apprehension will not work. You have any strong evidence? Show it, prove it. Point second, she spoke about her children's professional roles. On one of the primary grounds of recusal request was that Judge Sharma's son and daughter are empaneled as central government counsels. The judge ruled that the professional choice of judges' family members cannot be used to dictate judges' disqualification unless a direct nexus of misuse of office is proven. So, just because the judge says my relative is working with the government of India or is associated with central government and all that, that doesn't automatically make me, a case where I have to recuse from a case. How does that work? Am I directly involved in any way? That's the point number 2. Point number 3 is fundamental rights. She also said that barring family members from their profession simply because a relative is a judge would violate their human rights. Judge relative hai to family members cannot sit at home. I mean, you can't, that will be violating their human rights. So what she said, on participating in a legal event, she said the defense had pointed to her attendance of events that was organized by Akhil Bharatiya Adivakta Parishad. The judge dismissed this as a ground of recusal, stating that the judge routinely attended professional and academic program organized by various bar associations, and that such participation does not imply any political biasness. Now, Akhil Bharatiya Adivakta Parishad is an organization that is said to be associated with the RSS. So that is why Arvind Kejriwal had said, "Bhai, you are attending event or a function organized by part of RSS and then you are hearing me. So would that be fair?" Now, here let me also add, I have heard about judges who have even attended RSS events, forget an RSS and Sangh events. The judge says that doesn't make any difference and that doesn't call for her to recuse from this case. And the final point she made is that a litigant cannot be allowed to put the judiciary on trial. A politician cannot be permitted to cross the boundary and sit in a judgment over a competence of a judge. She argued that recusing under such manufactured allegations would send a message that judges can be intimidated or pressured by powerful litigants, which would harm the independence of the institution. She said, a politician cannot put pressure on the judge that, she has to get out or he or she cannot hear the case and all that. If that is what is happening, then every second politician will try and put pressure on the judge, will intimidate the judge. Fair point. But this has another side also. Therefore, a judge also cannot intimidate the world and its mother that, because the person is a judge, and I have showed you this visual many a times where, you have person standing with folded hands in front of judge saying that, listen, please help and all that. So it should not be either ways. So these were the points she made. And of course, she is the judge, she judged. So I'm sure we have to honor it. And that's the point. The last issue I wanted to talk about. And that is regarding her directives to the Delhi police, and therefore Delhi police says directive to all the media channels and digital channels and all, not to show that clip where Arvind Kejriwal was pleading his case in front of the judge. That had to be removed. We all got notices. We all removed it. Of course, it is the law of the land, and we all abide by it. The point what I'm trying to make here is not really legal, because legally there are provisions. But the point that I'm trying to make here is larger. Let me elaborate. You see, according to a High Court of Delhi notification, under the Chapter 3 of the General Principles of Governing Video Conferencing and Other Modes of Audio, Video, Electronic Communication, point 7 states that unless expressly permitted by the court, no person either at court point or at designated place at the remote point or advocate's remote point shall record or publish the proceedings or any part thereof conducted by video conferencing or other modes of audiovisual electronic communication. So there is a law in place. One doesn't deny that. But the fact remains that I wonder, and this is a very humble question, I wonder why this opaqueness? Why this opaqueness? Why are people not allowed to see what happened in the court? Why shouldn't an ordinary citizen see what is happening in the court? Why doesn't an ordinary citizen get a right to understand that this is what the judge said, this is what the litigant said, and this is what finally the justice was? Why shouldn't an ordinary citizen see it? Why is an ordinary citizen not having a voice? The judgment is final and binding. There is no question about it. But can't I have an opinion? Look at this clip.
You tell me under which section this video recording is prohibited. If you are doing some illegality, then today we are living in the era of transparency.
Take a videography. CCTVs are already.
But why? If you are doing something which is not permitted by law, and if a citizen intends to videograph it.
Assuming this is a petition. It's just one.
I don't want to assume. You just tell me which provision of law empowers you to stop someone from taking videography.
That is what I'm saying. That if this person, instead of this person, if it have been a terrorist, what would have happened? What would
don't put hypothetical questions to the court. Just answer the query of the court that which provision of law empowers you to stop someone from videograph.
This is also a judge. Now, one judge says that why are you not showing the video? Another judge says that don't show the video. Why? Isn't his logic applied to her logic? If one justice says one, another justice says another. What exactly is law? Is law only for the people? The judiciary is beyond law? Is that how it is? Why was that video pulled down? Why was that video being asked to pull down? What was wrong with that video? He made his case. I'm sure she made her case. And her case, legally speaking, she has put her points across. Now, and what she says is finally binding. But is it unfair for the people of India to have an opinion? I kind of didn't understand that, because I have heard this before also. When Supreme Court judge says, listen, you know what, pull down everything, no discussing about it, nobody speaks about it. I mean, is that fair? Is this where even the judiciary is going now? You see, judiciary is the last frontier for democracy. The point is, when a litigant, accused stands in front of a judge, the feeling should be of hope. The feeling should be of justice. The hope that I will get my justice. That is the feeling that one needs to see in that courtroom. Instead, are we instilling fear? Are we instilling opacity? Are we instilling, it's my word and that's it? It's the way I feel and that's it? Is the concept of judge becoming bigger than the concept of justice? That's the question I want to end this editorial with. Till I see you next time. That's tomorrow at 10. Namaskar.